Okay, so I'm going to lecture about 3 chapters on contracts. I have kind of picked a few topics. This is definitely not representative of all the information you will learn in these 3 chapters. So make sure you do read the chapters and look at the supplemental materials on Canvas. I just wanted to give you a brief lecture on these 3 chapters on contracts. So we can also discuss the assignment after I do the lecture. So and so I have condensed the 3 chapters, which are probably something like 90 slides, into 16 slides, just to give an idea how little we are going to cover. But I'm just going to give a high-level overview of these 3 chapters. So when we think about contracts, the first thing that we need to learn is that there are 4 requirements for a contract to be valid. Those requirements are agreement, consideration, contractual capacity, and legality. Agreement basically means that the parties that are entering into the contract, 2 or more people, are in agreement with the terms and conditions. They agree to it they agree to enter into the contract as well, right? The next one is consideration. Consideration means you are considering something to get into a contract. So think about it that both parties, or there are at least 2 parties to a contract, right? Unless it's a unilateral contract, but we're talking about contracts between 2 or more persons. So every person that enters into a contract gets something out of it, right? So if you're entering into a contract to buy a car, your consideration is to receive the car. Otherwise, you wouldn't give up the money. You're thinking about, oh, I'm getting this car that's about worth $10,000. So I'm going to give up $10,000 because I'm getting this car. So one other way to think about it is what's in it for you, right? And the other party, the person that would sell you the car, is the one that is considering the money they're receiving. They wouldn't otherwise give up the car freely. Otherwise, it would be a gift and not a contract, right? There has to be some exchange of value, right? Legally sufficient value means to be legally sufficient. Consideration must be something of value in the eyes of the law. So the courts don't care how much you pay for the car. You might pay way over market price, right? You can, if you agreed to the price and all the other elements of the contract are there and nothing illegal happened, the courts will not worry about it. You know, maybe the car is worth $1,000 and you paid $3,000. That doesn't matter. It's still a valid contract, right? Or maybe you're selling your car and it's worth $10,000 and somebody offers you $1,000. You agree to it. So without any pressure or threats, then that contract would be valid and you couldn't question the amount under court. Contractual capacity is the next requirement for a contract to be valid. So there's something that is special for minors. Minors, they can enter into a contract, but they can also disaffirm the contract. Minors are individuals under the age of 18, right? So if a minor enters into a contract before they turn 18 and they change their mind and they don't want that contract anymore and they don't want to keep those obligations, they can actually disaffirm the contract or avoid any obligation, right? They can also do that shortly after they turn 18. So if they enter, let's say you enter into a contract, you're 17 and a half, and then you turn 18 and then 2 months later you think, I don't really like this contract. I don't want to be part of this contract anymore. You can still disaffirm. But of course, if a reasonable time passes, depending on the nature of the contract, you could no longer disaffirm it after you turn 18, right? There are exceptions, of course. For example, an emancipated minor cannot disaffirm a contract. Ratification means if the minor turned 18 and did not disaffirm the contract, after a reasonable amount of time, that contract becomes ratified and the minor can then no longer disaffirm the contract. There is parents' liability if the parents sign as co-signers or under the contract to be legally liable for the minor. A lot of companies service minors. They sell products and services that they target minors. But they don't want to take that risk that the minor might disaffirm the contract, so they will ask a parent to sign, a legal guardian, I should say, right? A legal guardian would then sign the contract. But if the business does not require the legal guardian to sign the contract, then the minor can disaffirm. Questions so far? We can also do questions at the end. Intoxicated persons. Now, do intoxicated persons have legal capacity to enter into a contract? It all depends on how intoxicated they were, right? Based on that, it could be either voidable or valid, right? They have to be sufficiently intoxicated to lack mental capacity. If that is the case, then the transaction or the contract would be voidable, right? If somebody was completely intoxicated, didn't know what they were signing, didn't understand anything anymore, that contract would be voidable. If the intoxicated person was slightly intoxicated and understood the legal consequences, the contract is enforceable. Of course, those things are difficult to prove in court, but sometimes there can be witnesses that they can look at how many drinks a person had. There was a case in the textbook about a couple who was at a tavern. This was like in the beginning of the 1900s or something, long time ago, right? But they were there with a friend who always wanted to buy their farmhouse. And the couple didn't want to, the husband, the guy, didn't want to sell the farmhouse to his neighbor ever. Anyway, so they were sitting and eating and drinking, and at one point, the farmhouse came up again, and the husband said, yeah, okay, I'll sell you the farmhouse. But they were drinking, right? So they drafted something on the back of the receipt. They identified the property and the price, and they both signed it. And his wife also signed it, who was the co-owner of the farmhouse. Well, the next day, his friend wanted to hold him accountable and wanted him to turn over the property and pay for the property, right? Well, the man said, well, no, I was drunk. I didn't really mean that. Upon further investigation, they looked at how drunk he was, and he couldn't prove that he was intoxicated enough to lack mental capacity. And in addition, also because of his wife's side, who did not drink at all, he had to uphold the contract and sell the property to his neighbor. So be careful what you sign when you are drinking a little bit, right? Not that just because you are drinking doesn't mean you can avoid your duties under that contract. Mentally incompetent person, the contract can be void, voidable, or valid. It depends on the mental capacity of the person at the time the contract was formed. So if I sign a contract today, I have mental capacity. And maybe tomorrow, God forbid, I have an accident and I lose my memory or something like that. It doesn't matter. When I signed the contract, I had mental capacity. I still have to perform if I am able to perform. Now, sometimes there are things that you will read in the textbook about impossibility to perform. You could be excused, right? But unless that's the case and you can prove that, you still have to perform under the contract. All right, and the next element is legality. Contracts against the law are not legal. Contracts to commit a crime are illegal. They would not be valid under the courts. Usury means charging an illegal rate of interest. If you loan money to somebody and lenders charge good amount of interest, that's how they make money, right? Why would a bank loan you money? Right. However, there's a limit of interest a lender can charge by law. It's something like 28 or 29%. It's ridiculously high, right? But still, you can't charge more than that, right? If somebody entered into a contract, loaned somebody money, and charged more than that legal interest rate, or the limit of what you can charge as an interest rate, the contract would be voided, right? Gambling is illegal in most states, and those contracts are illegal, so they would not be valid. Not valid means they cannot be enforced by the courts either, right? And then licensing statutes. Certain services, certain type of work requires licenses. A medical professional needs a license to perform some type of surgery, right? an electrician needs an electrician license to perform work on your electrical wiring in your house, right? Now, if you enter into a contract with a person for that work that requires somebody to have a license, and that person is not licensed, that contract becomes illegal and cannot be enforced under in our legal system.
Contracts.
Was that a question or is that background noise? Oops, I'm trying to mute somebody here. Okay. All right. So don't enter into contracts with people that don't have a license just to save some money. You know, electricians is actually a good example. Electricians can be quite expensive. They have very good training. They have studied, learned, received their licenses and all that stuff. So they are charging according to that. Sometimes people might be tempted to hire unlicensed electricians because they do the work for half the cost. But if you do that and enter into a contract and you know that person doesn't have a license, that person did not present you a fake license, then you cannot enforce that contract. So be careful. Next slide. Undue influence is persuasion that is less than actual force, but more than advice, that induces a person to act according to the will or purpose of the dominating party. Sometimes people have kind of power over other people, personal power. It could be a parent, a spouse, a boss at work, right? That you feel intimidated by. And they might influence you to enter into a contract. So if there's undue influence, that contract could be voided. Again, you have to prove it, right? Duress is when somebody actually forces you to sign a contract. So it could be both a defense to the enforcement of a contract and the ground of rescission of a contract, but depending on which way it goes. But duress is something, it's different from undue influence. You are in a situation where you had to do something, right? Okay, any questions about the 4 elements? Again, the 4 elements were agreement. People have to agree to the terms of the contract and either verbally agree or agree in writing. By signature, consideration, there has to be some value of some exchange of something, right? Money and a product, or money and a service, or a product to a product, whatever, some kind of exchange, right? And there has to be legal capacity, right? People have to have the legal capacity. They cannot be intoxicated or mentally not capable of understanding the contract. And then the last one is legality. The subject matter of the contract has to be legal. All right, the next topic is contract performance. When is a contract performed? Remember this slide because there's a question on this week's assignment about this. An executed contract is a contract that has been fully performed by both parties. In other words, everybody is done. You got, if you're buying a car, you got your car, you paid for the car. Maybe you're making payments. Maybe it took you 3 years to pay it off. After 3 years, after you make that last payment to receive the title, it's executory. Once you paid off the car, it's executed. Basically, it's kind of like you shake hands and say goodbye. There's no more relationship between the parties once the contract is executed. It's basically over, right? If you live in an apartment and you sign a lease and you live in there for 6 months, the contract is executory for 6 months. If you move out after 6 months, then it is executed after the landlord returned the deposit and all that. All right, and the next one is I picked these topics because they're part of the writing assignment. So there's a writing requirement. Not all contracts need to be in writing. Some contracts can be verbal, and I want to define what a writing requirement is at first, because sometimes people think a written contract has to be something that's printed out on physical paper and has to have a signature in ink. That is not what a written contract means. A written contract means there's a document, the contract is saved somewhere, either on paper or in digital format. A digital contract is also a written contract, right? As long as it follows all the requirements of a contract, right? So some contracts need to be in writing, others don't. So, and when you answer that question on the assignment, look at this slide and read about this. I think this is in chapter 9, I think, or maybe it's already in 10. So contracts involving interest in land. So basically real estate contracts have to be in writing. As a matter of fact, when you purchase real estate, signatures have to be even notarized, right? Contracts that cannot be performed within 1 year after the date that they were formed. So if you sign a contract today and the contract will take 2 years, let's say, it has to be in writing. If you buy a car and you finance it for more than a year, it has to be in writing. Cars have to be in writing most likely because of number 5, but I'll get to that. But the third point is collateral or secondary contracts, such as promises to answer the debt or duty of another. So if your parent co-signs, let's say you're going to college, you're transferring to a 4-year college, and you're going to rent an apartment, and even though you're 18, it's very likely that the landlord is going to require a parent or a legal guardian to co-sign the contract to answer for your debt in case you don't pay, right? They do that because most likely students don't have a lot of credit history and income, and the parents are the ones paying the rent anyway, right? A lot of times, not all the time. So that those type of contracts have to be in writing. Another one is marriage. Marriage contracts have to be in writing. Just saying I do is not enough. You have to actually sign, do it in writing. And then number 5, under the Uniform Commercial Code, contracts for the sale of goods priced at $500 or more. Of goods, not services. So if I hire somebody to paint my house and I'm paying that person $2,000 to paint my house, that contract does not have to be in writing because I'm paying, and that will be completed in less than a year, right? So for services, it doesn't count the $500. For services, the time limit is important. But for goods, if I buy a car that costs more than $500, the contract has to be in writing. So that's a writing requirement. And that is also a question on this assignment that we have this week. Okay. Next is assignment and delegation. So assignment is when you transfer the rights that you have under a contract to somebody else. A great example for that is if you lease an apartment and you're going somewhere, you're not going to live there for the 3 months in the summer, you sublease it now to somebody else. You basically assign somebody else the rights to live in that apartment. You would also assign them the duties to pay the rent, but it depends on the agreement you have with the landlord and if the landlord allows assignment or not. Some landlords, most likely in college towns, they will allow you to sublease it. But other than that, landlords don't like it if you sublease the place. If you have a 1-year contract, you're responsible. You're responsible for it anyway when you assign to somebody else. And if they fail to pay the rent, you're still responsible because you're the original party to the contract. And the next one is delegation, the transfer to another of all the parts of one's duties arising under a contract. A good example is if I'm a painting company and I paint houses, and a homeowner hires my company to paint the house, and my company is very busy. I can hire a subcontractor and transfer the duties to that subcontractor to paint the house. Now, if the subcontractor does something wrong, I'm still liable. If they damage the house, I can't say, well, sorry, it wasn't us. We just hired a subcontractor. The original party is always still liable. Damages, when you sue somebody for breach of contract, breach is another word of breaking a promise in the contract because a contract is you're promising to do something, right? The types of damages, there are compensatory, consequential, punitive, and nominal damages. Compensatory damages are those that compensate you for the losses you had because somebody breached your contract. Let's say you sign an apartment lease for a year and you move out after 8 months, and the landlord cannot find somebody right away to take over the last 4 months, and you just take off and don't sublease or anything, right? And they lose, maybe your rent was $1,000 a month. Now The landlord lost, maybe they can't fill it at all. They lost $4,000. So they need to be compensated for those $4,000. That's because you broke that lease, right? So you would have to pay them $4,000 if everything goes to court and can be proven, right? Consequential damages are in addition to compensatory damages. Let me see. Maybe, okay, let me use this type of contract. So you're a restaurant and you have a contract with a restaurant supplier that supplies you steak, right? You have a contract, they will supply you 50 steaks a week. And the contract is ongoing for 6 months, right? You know, that's your steakhouse. You really need the steak, and the supplier stops supplying you the steak. And let's say you already paid for the steaks for that month or week, let's say that week, right? Well, the compensatory damage would be for you to receive the money back, right? That you paid for the steaks that you didn't receive. The consequential damages would be the money you lost in profit because now you couldn't sell the steak dinner and people didn't come to your restaurant to eat steak. If you can prove that you lost business because, as a consequence, because somebody breached their contract to supply you goods, that would be a consequential damage. Punitive damages is something we covered actually in chapter 3 when we talked about the McDonald's case, or when you read about and looked at the video, hopefully, about the McDonald's case. Punitive damages get awarded on top of the compensatory and sometimes consequential damages to when the case was so bad, when the company or the organization or whoever breached it was grossly negligent and reckless, you know. So the judge might just put extra punishment. In the McDonald's case, if you watch the video, originally the judge said something like 2 days of coffee sales. You know, they were suing for, I don't know, 300,000 or something, and the judge awarded $2.some million, right? So, and then the last one is nominal damages. Sometimes just $1 is awarded, just to make it a point. You know, maybe there were not a lot of damages, but it was still a bad example. So to show who was right or who was wrong, $1 will be, or a small amount will be awarded. All right, mitigation of damages, especially of consequential damages, is the person that did not breach. So in the example of the restaurant at the steakhouse, right? Let's say the steakhouse just, the steakhouse in this case, in this example that I gave, they have to make an effort to get the steaks from somewhere else. They can't just sit back and say, oh, good, I'm not getting steaks. I'm just going to charge them for my profits that I'm losing because they're not delivering me the steaks anymore. You can't do that. Instead, you know, as the non-breaching party, at the other party of the contract, you need to mitigate the damages, keep the damages to a minimum. Another example of mitigating damages is if you are in a building and you have a contract with you know, your tenant or your landlord or whatever, but there's a water leak, right? As soon as you notice there's a water leak in your place that could damage your floors or your furniture or whatever, you have to stop turn off the water. You can't just say, oh, I'm just going to let this leak for a week before I report it so I can get my carpet replaced for free or something like that. You can't do that. You have to mitigate damages, right? Other stuff, arbitration agreements and release of liability, those two topics come up also in this week's assignment. We did cover arbitration agreements in chapter 2. This is when you sign a contract and you agree not to take the other party to court if there's a disagreement, but instead that you will solve your case in through an arbitrator that they usually name in the contract, right? That's an arbitration agreement. And release of liability, you will find those if you, for example, do this assignment that we have this week on a gym contract. When you sign a contract with a gym, you agree to release liability. You will not hold the gym liable for any injuries you could sustain at the gym while working out, right? That you're not, that you cannot sue them. That would be release of liability. All right. Let me just stop sharing this. And okay, so here's the assignment we have this week on contracts. For this assignment, you have to use a contract that you have already entered into, and you have to attach a full copy of that contract. Now, a few of you in this class might be underage, and you may not have entered into that type of contract that would work for this assignment. You can also use a contract of your parent or another relative or a sibling, even a friend, as long as that friend is not in this class and doing the same assignment on the same contract, right? Once you find the contract, the type of contracts that work really great would be a gym membership, even the purchase of an automobile, a lease or rental of an apartment, some internet service agreement, or any other type of contract where you are a party to, or one of your parents or relatives or somebody, right? Don't use agreements for online services such as social media, music, or any other free portals, right? You can use things like Netflix or Spotify if you are using the paid version, right? For free, don't use any free services. Let's see, so what else? Don't use any employment contracts, don't use any non-disclosure agreements, don't use any contracts about being on a sports team or anything like that, right? Unless you're like on a college sports team. Unless you're on a club team and paying for the service of being part of that team, that would not be a good contract for this, right? Again, make sure you include a full copy of your contract. You may want to black out personal information like your name, address, social security number, and all that stuff, right? I don't need that. Your name should be visible. If you're using somebody else's contract, just mention it that you're using somebody else's contract, right? If you don't include a full copy of the contract, you will not get any points. I have no way of looking up your answers if I don't see your contract. This is not a typical textbook question where I know the content or anything. I don't know what your contract looks like, right? So unless you submit your contract, I won't know the answers. Also, before I even get to that point, you wouldn't know where to look up the answers if you don't have the contract, right? So once you have to find the contract anyway, just submit it with your assignment. You can submit it as an additional submission. You can attach it or copy and paste it into your file. If it's an online contract, if it's something like, let's say you're doing a Netflix or something like that, they have their user terms and agreements and all that stuff online as well. Just make sure you have you include the link to that, right? And then here are the questions that you need to answer. What's the contract for? So if you're using it for let's say a gym membership, this contract is for a gym membership. Who are the parties to this contract? Such as ABC Gym and myself. Briefly describe the consideration of this contract. Remember, consideration was what's in it for you. So your consideration would be you get to use the gym, let's say 24/7, and you get to use their equipment and their showers and hot tubs or whatever they have, right? That's your consideration. Why are you willing to give up a monthly amount of a certain amount of money every month? Because you get to use the gym, right? The gym's consideration is for you to receive money from you, right? How were the terms accepted? I know from personal experience, a lot of times when you go to the gym and try to sign a contract, you just sit in front of a computer and click, I agree, I agree, I agree, right? And then that's pretty much it. But maybe it's different. Maybe they print it out and you sign it that way. Just describe it. And then the question number 5 is this contract executed or executory? Remember what I just said in the slide. An executed contract is when both parties have fully performed and there's no more relationship with the parties. So let's say you canceled your gym membership, you're no longer a member. That's when the contract is executed. However, as long as you're still a member, the contract is executory, right? Is the contract legal? Yep, hopefully you're not going to use an illegal contract for this assignment, right? You probably don't have one anyway. Did you have legal capacity and were you a minor? Just state that, right? Hopefully you weren't intoxicated when you signed the contract. Does this contract need to be in writing and meet the writing requirements? Now, typically a gym contract doesn't need to be in writing unless it's a contract for more than 1 year, right? Remember, service contract or a contract that cannot be completed in a year have to be in writing. Don't give me reasons like, oh, this is so complicated, nobody would remember the details, so that's why it has to be in writing. That's not why it has to be in writing. You can still have a contract, but it would be a verbal contract instead, right? Of course, most gyms are smart and they still do it in writing because they choose to, but by law, they don't have to be in writing, right? How and when can this contract be discharged or canceled? Usually it has some terms if you want to cancel it. A lot of times gyms now don't do year contracts anymore. They do month to month, but then they have a thing where it says you have to give 30-day notice or something like that, right? Has this contract been assigned or delegated? Gym contracts typically cannot be. You are the member, you're paying it, and you can't transfer your rights to somebody else. Let's say you signed a gym membership and your friend wants to use it. They can't use your gym membership. You can't transfer those rights or assign your duty to pay to somebody else, right? Your parents might pay, but if you signed it, you're still responsible, right? Are there any third-party beneficiaries? Most likely not for a gym, right? Are there any arbitration clauses? Some of them will have that. Again, this is where you give up your you don't give up, you agree to not sue them in court if there are any problems or disagreements, but you will solve any disputes in arbitration. Does this contract really require release of liability? 99.9% if you're using a gym contract, yes, it will require a release of liability, and describe it, right? And then after you complete this exercise, do you think it's fair or one-sided? A few things to remember is, okay, this is not an essay. You're just going to write question number 1, 2, 3, 4, and so forth. Just list the question number. You don't need to retype the question. If you prefer, you can, of course, but you don't have to. And then answer it in full sentences, right? And submit it by Sunday night. So that is this assignment. I'm going to stop the recording real quick and then we can ask some questions. 1 second.